So in this video, we're going to talk about what we call fiduciary duty quicksand. And the reason I call it quicksand is I just feel like there are times as agents where you think the path ahead looks all clear. You take a few steps and you feel a little stuck. You don't get out right away, and now all of a sudden you're stuck a little further. Now the more you try to get out of it, it just gets worse and worse, and all of a sudden you're really stuck in the quicksand, right? If you could rewind the clock, you never would have imagined that this is such a sticky situation as you approached it. But now that you know it's sticky, you would reroute yourself around this quicksand, right? You wouldn't even dip your toe in it. And so that's really the purpose of this discussion, is to cover key areas where I think agents will sometimes find themselves surprised that this turned out to be as sticky as it ultimately did. Really, the key here is that anything to do with fiduciary duty really strikes at the core of what it means to be an agent, right? You are licensed by the government to look out for the best interest of your client. It's really what it means to be an agent. And so if you are found in these situations where you actually didn't act on the best interest of the client, that's really problematic for you if your file or your transaction or actions are looked at by the Department of Real Estate, context of ethics, or anything else, right? Most agents are well-intentioned, and so this isn't usually a question of intentions, it's a question of the situation got a lot more complicated than someone saw, and there's nuance that can be really difficult to avoid, in particular in these scenarios that we're gonna jump into. First type of fiduciary duty quicksand is divorce sales or court-ordered sales. So some sales of real estate in a divorce are court-ordered. There's other types of sales. Sometimes, a common one is a group or a pair or group of siblings that have inherited a property. They don't get along. One of them wants to sell, the other one doesn't, and now they've gone to court and they're suing to force the sale, similar like in a divorce. What this means is that you as the agent represent two people who don't get along, who really don't get along so much they've hired attorneys to fight. And so what that means is it's a volatile situation, right? It sounds maybe simpler initially that, hey, I'm just gonna, market and help get your property sold. It's gonna be simple. But as anyone who's been in the business a while will tell you, there are tricky things that can sometimes surprise you and come up in the middle of a transaction. And how do you handle the communication of that? Or when you have two clients who can't really agree on anything, which is why they're in this situation in the first place, but they need to agree in order to move forward because they're gonna have to sign the same documents on a purchase agreement, on a listing agreement, an amendment, a request for repairs, any of these other things that could come up, they're gonna have to agree. And it's really tricky for you as the agent who represents both of them. You have the same fiduciary duty to these two factions that are upset with each other, but you represent them both equally. So your communication needs to be impeccable in that it's between both of them in writing. So even if you're having a conversation on the phone or you receive a phone call from one of them and they relay some information, you can't be withholding that from the other one, all right? So that's now you're sending confirming letters. So meaning you're writing an email to all the parties, just confirming what we just talked about, and this information is being shared with everyone. Those situations have a way of really quickly spinning out of control, especially it's almost even worse if you have, say, a divorcing party where one of the spouses is not represented by an attorney. They're trying to represent themselves, which means they're even more so going to try to be leaning on you for things they shouldn't be leaning on you for. They should be leaning on an attorney, but they're not. If both parties are represented with attorneys, it's actually easier. You're just including the attorneys in all the correspondence. But it's just something to watch out for. This isn't the type of quicksand that you have to avoid. I mean, there's actually a niche in good business. It's just more you need to know that it is quicksand, and the best way to stay safe from it is just being impeccable with your communication and the fairness in which you're handling both your parties who at odds with each other. The other layer just to acknowledge as a part of this is how you came to represent both of them. So if there are attorneys involved, sometimes one party will propose some options and the other party will choose the agent. So they'll propose 3 agents and then the other side chooses it. But you're chosen by someone. You're not chosen by the other one. That means one of them didn't really want you. And so that can add a complicated dynamic. And as soon as you deviate at all from professionalism in your communication, that's when the quicksand starts. So it's not the transaction that's the quicksand, it's your deviation, maybe to be friendlier or to retain that kind of emotional rapport and connection with the client. Now you're in the quicksand and it only gets worse from there. So I think just maintaining that professionalism without fail from the beginning of those transactions is really key. Thanks for watching. I hope this was helpful. If you learned something or if this helped you solve a problem, follow me for more.